Thanks to Indochino for keeping Legaleagle in the air and helping me look fly. The Senate impeachment trial of President Donald Trump has begun, and day one was filled with fireworks, bombshells, lies, and deception. Things that bode well and terribly for your case, whether you are a Republican or a Democrat. There was something for everyone. So let's dig into all of the craziness that happened on day one, and let's also find out why Senator Ted Cruz apparently is singling me out for trolling. Hey Legaleagles, it's time to think like a lawyer because the first day of the impeachment trial in the Senate was filled with all kinds of lawyer skills and complete sophistry. So let's dig into some of the more important things that happened during the first day because a lot has changed and it's going to set the tone for the rest of the impeachment trial. The first day of the trial was ostensibly about setting the rules for the rest of the trial, and indeed they did in fact set some ground rules for the rest of the trial. Interestingly, in the run-up to this first day of the Senate trial, Senate Majority Leader Mitch McConnell had said that he was going to pattern the proposed rules off of what was used in the impeachment trial. The idea being that if it was good for the trial of a Democratic president, it would be good for the trial of a Republican president as well. The proposed rules had been held back, and it was only over the weekend that we got to see what the proposed rules were going to look like. And interestingly, McConnell had made several key changes to what was proposed compared to what was used during the Clinton impeachment trial. For instance, two of the major key changes included that all of the argument would have to be compressed into a 24-hour period spread out over 2 days, and that the evidence that came from the impeachment hearings in the House would not be admitted automatically into the Senate trial. Those were big deviations compared to the Clinton-era rules. But interestingly, it seems that those changes were repealed at the last minute after a meeting with some of the more moderate Senate Republicans. So now the rules that were approved on a strict party line vote require that the argument be made over a 3-day period, which is commensurate with what happened in the Clinton trial, but also that evidence from the impeachment hearings in the House can be admitted into evidence in the Senate. However, with one big caveat that is a deviation from the Clinton trial, that the evidence is subject to objections from the White House or other senators, including hearsay, which is problematic to say the least. Now, of course, the Senate can make whatever rules it wants. It can adopt the federal rules of evidence or not. But what we've seen is that there are plenty of misunderstandings about what hearsay actually means, and we've covered some of those misunderstandings on this channel. It's going to be problematic because here a lot of the testimony that is relevant to the president's motivations and the president's actions are necessarily going to include things that other people have said. Those things, for example, what the president told Rudy Giuliani or Mick Mulvaney, those things are relevant in and of themselves as legal acts, which would defeat an argument that they're hearsay. But even things that Rudy Giuliani told other people, including potentially Lev Parnas and other associates of Giuliani and the president, would potentially be considered hearsay, but they would be admissible in court if it were an actual court because they are declarations against interest or declarations of a party. There's all kinds of reasons why even, quote, hearsay evidence would come in. So the carve-out is particularly interesting from a legal perspective, but it is ripe for abuse because people simply don't understand, sometimes willfully don't understand the idea and concept of hearsay, especially in this context. And as I mentioned, it was a straight party line vote. 53 Republicans, no defections to 47 Democrats, no defections. Now, not only did the Senate procedural rules cover the amount of time given to both sides to make their case and their defenses and the admission of evidence that was procured during the House impeachment proceedings, but it also covered the new evidence that will be added to the Senate trial, or more specifically, it did not cover the evidence that will be added to trial. For all intents and purposes, the Senate is kicking that question down the road. Though that's not necessarily the end of this story. The senators can always pick up this question again, with some of the more moderate Republicans arguing that they will make a second decision once they have heard all of the argument from the House managers and the president's defense attorneys. And that does comport with what happened in the Clinton trial, where that decision was not made up front, but was made several weeks into the Senate trial. Though it's also possible that the senators will not take up this question again, and there will be no additional new evidence in the Senate trial, which raises the specter of what commentator Dalia Lithwick sort of summarized the Senate GOP position as it's too late for impeachment witnesses, and it's also too early for impeachment witnesses. The Senate GOP has been arguing that the witnesses should have been called in the impeachment hearings in the House, and that it's also too early to address that question in the Senate. And also, by the way, no witnesses should be allowed in either the impeachment hearings in the House or in the Senate impeachment trial either. And the Republicans argue at the same time that the Democrats should wait for the courts to decide these questions of the subpoenas themselves and whether the witnesses can be compelled to testify. At the same time, arguing that the courts have absolutely no right to decide these questions because of separation of powers issues. It does often feel like the arguments are that it's never the right time and it's never the right forum to decide these questions. Again, in strict party line votes, the Senate Republicans voted to dismiss 11 amendments that Senate Minority Leader Chuck Schumer tried to add to the Senate rules, each of which attempted to bring in various kinds of evidence into the Senate trial, including subpoenas for documents and witnesses from the White House. These amendments would have approved subpoenas for things like communications between the White House and Ukrainian President Zelensky, documents and testimony from individuals like Acting Chief of Staff Mick Mulvaney, Secretary of State Mike Pompeo, and former National Security Advisor John Bolton. And in a really interesting gambit, one of the amendments would have allowed Chief Justice Roberts to make the call as to which subpoenas for testimony and documents would be approved. But again, along strict party line votes, the Republicans voted not to allow any new evidence to come in and voted down an amendment that would have vested the power to decide whether new evidence would come in with the Chief Justice presiding over this trial. The next set of fireworks came from the Democrats, who came out swinging and arguing substantive points on the first day of the trial. Now, by all accounts, it was thought that everyone was simply going to discuss the procedure and procedural rules that were going to govern the rest of the Senate trial. The Democrats used their time in their opening statements to talk about the substantive arguments for impeachment. Whether you like this tactic or you found it to be complete histrionics, this is an interesting and classic trial tactic to use all of the time that you have allotted in front of the trier of fact or the trier of law to get your point across. This is something that happens in lawsuits and trials all the time. I've seen it many times where lawyers argue with a judge, digging straight into their arguments when the judge doesn't really have any idea of what they're talking about. Whereas if you give some background and argue a lot of your substantive points up front, then the more nuanced points that you might make later on will actually resonate with the judge, who has a million things on their docket. And the tactics that Adam Schiff and some of the other Democrats took on the first day of this Senate trial sort of harken back to that particular trial tactic, that instead of simply arguing the mere procedural points, which they eventually did, especially with Chuck Schumer, they took that opportunity to start making their case in front of the senators and the American people. So whether you liked that tactic or not, whether you thought it was pure grandstanding or you thought the Democrats were making some good substantive points, it has its basis in classic litigation and trial tactics to be able to get your story out at every avenue that you can and not just be cabined into the specific issue in front, but to be able to talk about all of the issues at the same time. Because of course, if you have a theme, you want to reiterate that theme or that narrative as many times as you can, hoping that it will stick. And of course, it was interesting to compare the Democratic narrative, which went into the substantive issues, with the narrative put out by the lawyers for the president, who it appears were prepared to argue for the substantive points, but perhaps not all of the substantive arguments on day one. Which leads me to the next part of this impeachment trial that really struck a chord with me as a practicing lawyer, was the marathon nature of this particular proceeding. This may be a feature, not a bug. When you're in trial, the judge sets the schedule, and there's a reason why often trial starts at 10 a.m. and wraps up by 4 p.m. with maybe 2 to 3 hours of substantive things actually happening during the day. And the reason is that the jury will get fatigued over time. It's really, really hard to be glued to your seat for a full business day listening to all of these really complex and arcane arguments. And of course, the same thing is in effect with the Senate trial as well. This day one of the trial went long into the night, and unless you are a legal freak like me, you probably had better things to do during the day than to watch 12 hours of testimony and argument on C-SPAN. That has an effect. It's very clear that both sides are going to get fatigued, that the American people are going to get fatigued, and that cramming so much into one day, it's going to be hard to follow all of the different things that are happening, and things are going to get chopped up into sound bites by both sides, and it's going to be really hard to pay attention as the weeks go by and this continues. Now, one thing I thought was particularly interesting is that both sides, both Republicans and Democrats, are arguing that these impeachment proceedings, both in the House and the Senate, are precedent-shattering and are hugely different from everything that has come before. And in some respects, they're definitely both right. And one of the reasons for that, and one of the huge reasons why the evidentiary issues are so incredibly important in these impeachment proceedings compared to impeachment proceedings in the past, is that there was no independent investigation. By necessity, the House had to do the investigating, which it's really not set up to do and is bound to get locked up in separation of powers issues. In the only two other modern examples of impeachments, we had an independent counsel doing the investigating. In the Nixon era, we had Special Prosecutor Leon Jaworski, who was able to do a thorough investigation into the Nixon affair, including being able to subpoena documents and testimony from individuals, which admittedly went up to the Supreme Court, which forced the White House to turn over the famous Nixon tapes. And that's one of the reasons the investigation took years to complete. In the Clinton era, we had independent counsel Kenneth Starr, who again had the full force of the executive branch to do an investigation into the various Clinton affairs. Often when you're talking about impeachment in the House, the analogy is made to the criminal context where the impeachment is an indictment. There is some investigation, but often you are waiting for additional evidence to come out through further investigations, where the trial in the Senate is like a criminal trial in real life, where it can use the evidence that was found in the House impeachment indictment, so to speak, like a grand jury investigation, but more can come out during the Senate trial itself. That analogy is probably a good one, but in practice, what we have had is in the last two impeachment proceedings, there was a thorough investigation done before it ever got to the trial in the Senate. And of course, when it comes to the Nixon affair, it never even got to the trial in the Senate. And House Manager Adam Schiff made this point on the floor of the Senate during the first day of the trial when he said that the Clinton impeachment trial was more about recalling witnesses than it was about calling witnesses in the first place. So regardless of which side of the aisle you happen to stand, this is very different. And it may be different out of necessity because we don't have an independent counsel. One was not appointed by Attorney General William Barr, and we don't have the same kinds of laws that would have appointed a special prosecutor like Leon Jaworski to do the investigation that the House necessarily had to undertake, which is very, very new. Of course, another legal bombshell came actually from the defenders of the president and may have severe repercussions for ongoing litigation. Because the president's defenders argued that the Democrats should have waited for the courts to decide a lot of these evidentiary issues and procured more evidence in the House before going to the trial in the Senate. The thing is, there's active ongoing litigation over the subpoena to former White House counsel Don McGhan. The White House has argued that the courts have no business adjudicating the White House's refusal to turn over Don McGhan for testimony. The DOJ, as recently as last month, argued that courts can't adjudicate the privilege issues for separation of powers issues. The thing is, on the floor of the Senate, the president's attorney Sekulow argued that Democrats rushed things and should have waited for the judiciary to weigh in.
The rush to impeachment, to not wait for a decision from a court on an issue as important as executive privilege. The president's opponents, in their rush to impeach, have refused to wait for complete judicial review.
Other lawyers for the president are in court saying the exact opposite of what they're telling you today. They're saying you cannot enforce congressional subpoenas. That's non-judiciable.
That is such a stunning admission and contradiction that if I was one of the lawyers working on that particular case, the Don McGhan case, I would probably file an emergency motion with the Court of Appeal saying that the Trump administration's basically conceded the issue and that the Court of Appeal needs to compel the testimony of Don McGhan. Now, there's sort of a pet theory going around the internet that Chief Justice Roberts, as the presiding judge over this trial, can save a lot of these issues and can rise up and can prevent some of the obfuscation from the Republicans. I would say that that theory was dealt a serious blow during the first day of the trial when Roberts really didn't do anything and wasn't even given some of the power that the Democrats want him to receive. And that Roberts is really just going to try to disappear and fade into the background like his predecessor William Rehnquist did. Really, the only thing that Chief Justice Roberts did on the first day when he chose to speak was to dress down both sides and say that neither is upholding the decorum that is required for these proceedings.
I think it is appropriate at this point for me to admonish both the House managers and the President's counsel in equal terms to remember that they are addressing the world's greatest deliberative body. One reason it has earned that title is because its members avoid speaking in a manner and using language that is not conducive to civil discourse.
But that's sort of par for the course. That's what you would expect the Chief Justice to do, to fade into the background and let the political bodies deal with the political questions. So I would expect more of the same, more fading into the background and both sidesing all the issues. Of course, in one of the biggest surprises, Senator Ted Cruz apparently singled me out by intentionally misusing the famous table-pounding quote.
You know, there's an old saying that if you have the facts, you bang the facts. If you have the law, you bang the law. If you don't have either, you bang the table.
Now, of course, I can't be certain that Senator Cruz is singling me out by misusing a quote that I've used many times on this particular channel, but it really does feel like he's turning it on its head when the Democrats, whether you liked it or not, spent hours upon hours talking about all the evidence that the White House is holding back. The fact that they haven't produced a single document or allowed any White House witnesses to testify in the House or the Senate. Whether you liked it or not, they were talking about the substantive arguments and making use of the evidence and law that is relevant to this particular case. And of course, the craziest thing of all is that while this is all going on in the US, President Trump is in Davos, where he gave a press conference where he specifically bragged about how he is not giving the Democrats any evidence and that he's holding it all back.
We're doing very well. I got to watch enough. I thought our team did a very good job, but honestly, we have all the material. They don't have the material.
Now, if I was trying to be charitable here, I would say that President Trump is just saying that all of the evidence is in his favor. But he specifically uses the word material, referring to the actual physical things themselves and not their metaphorical significance.
We have all the material. They don't have the material.
So it really does seem like the president is bragging about obstructing Congress and preventing them from getting any of the relevant evidence, and not the fact that he's just bragging about how the evidence supports himself. It really is sort of hilarious that the president always seems to say the quiet part out loud. And by hilarious, I mean that in the saddest way possible. So the Democratic argument often boils down to saying that the president is a liar, and his pants are on fire. And if his pants really are on fire, then he should really buy some new ones. So, Mr. President, if you're looking for a custom slim cut suit that is shockingly affordable, I can't recommend Indochino highly enough. All of my suits are now made by Indochino, including this brown checked three-piece. And if this suit looks familiar, it's because I unapologetically stole the design from Blake Scott. Blake, just know that imitation is the highest form of flattery. There's just one thing I wanted to change, though. I wanted to change the lapel from a notch to a peak. And with Indochino, not only could I choose the fabric so it was exactly the same, but I could tweak it so that it was 100% my own and 100% custom, which is exactly what I did. See, the secret to a great suit is all about the fit. I'm a reasonably athletic guy, and I can never buy suits off the rack because they just simply never fit right. If the shoulders fit, the waist is too small, it either doesn't fit or it costs a ton to have a tailor fix it after the fact. But with Indochino, you can send in your measurements online, or you can go to one of their stores and have a stylist take your own specific measurements. I made an appointment, I went to a store in person, and had a stylist work with me for over 90 minutes to make sure that my fit was exactly right. My personal stylist took my measurements, and a couple of weeks later, I got the best fitting suit of my entire life. It was perfect right out of the box. Indochino will make you a fully custom suit tailored specifically for you for less than $400. And the best part is, because they still use the best materials like Super 140's wool and cashmere. In fact, Legaleagles can get any premium Indochino suit for only $359. That's $359 for a custom suit that you design yourself. All you have to do is use the link in the description or use the promo code Legaleagle at checkout. Using the link in the description really helps out this channel. I will never buy an off-the-rack suit again, and once you try it, neither will you. Just click on the link in the description. So, do you agree with my analysis? Do you think we'll see new evidence in the Senate trial? Leave your objections in the comments, and check out this playlist over here for all of my other real law reviews where I talk about impeachment-related things, copyright, all of the legal issues in the news, where I will see you in court.